everybody, my name is Nicola Wallbank and I'm a partner at Julian Taylor Solicitors. We're a specialist employment law practice in Oxfordshire. Welcome today to the first in this series of tips for employers. The first talk in this series is going to be about redundancies. So as employment lawyers, we are very commonly asked questions about redundancies. Might be a big company looking to close an entire location, or perhaps a smaller employer looking at scaling back a single team by making one or two redundancies. We also get asked for advice from employees who perhaps feel like they're being unfairly selected or targeted for redundancy. So we've really come at this topic from all angles, so I feel well placed to talk to you about it today. Today we're going to focus on redundancy exercises where you're making fewer than 20 redundancies. If you are contemplating making 20 or more redundancies within a period of 90 days, then there are additional requirements for collective consultation and notification of the Secretary of State, and pretty significant penalties for failure to comply with that collective consultation regime. I've only got half an hour or so today, so we won't be focusing on that collective regime, but it's really, really important not to forget about it and make sure that you look at that and take advice or comply if your numbers are creeping up to near the 20 mark. And that's not just 20 in one batch. If you're going to be totting up 20 in a period of 90 days, albeit in separate batches, then those obligations can also be triggered. Broadly speaking, redundancy is used to describe a situation where you've got an employer who decides to reduce the number of employees, either within the business as a whole or within a particular site or function. But there can be many contexts or reasons for making redundancies. It could be recession or other economic pressures. It could be changes in the nature of products or services that are going to be provided by a business, an internal reorganisation to improve efficiency, or the relocation of an office, or even maybe technological advancements resulting in changes to job functions. What is clear is that a redundancy doesn't just arise where there's a poor financial situation within a business. It can also arise where you have a very successful employer with plenty of work, but who's reorganising to maximise efficiency. And it's really important for businesses to be able to make those sorts of decisions. And the key thing to remember is that the law doesn't interfere with an employer's freedom to make commercial decisions about the way its business needs to be run. Provided a tribunal can be satisfied that redundancy is the genuine reason for dismissal, it won't generally drill into and probe into the commercial reasons for why the business has taken that business decision. Sadly, many employers in recent months have been driven to looking at redundancies as a means of reducing costs. But in looking at redundancies, there are actions short of redundancy that can also be considered before you get to that last resort of actually terminating people's employment. And just to name a few, obviously there's the furlough scheme at the moment, which many employers have been using as an alternative for the time being. There are recruitment freezes, withdrawing job offers, deferring new starters, reducing use of agency staff, and also potentially even reducing hours or implementing pay cuts with due consultation. All things to be thought about before you reach that final option of contemplating redundancies. So redundancy is a potentially fair reason for dismissing an employee, and so the existence of a genuine redundancy can give an employer a defence to an unfair dismissal claim. So the first key question that needs to be considered, and I'd recommend to anybody contemplating redundancies, is to start with an analysis of whether your particular proposals fit within the definition, the legal definition of redundancy. And that's a definition embodied in section 139 of the Employment Rights Act. And it effectively covers three broad situations: closure of a business, closure of a particular workplace, or the ceased or diminished need or requirement for employees to carry out work of a particular kind. So taking those three limbs in turn, firstly, the closure of a business. So for an example, an employer decides to close down its entire manufacturing business because it's just not economically viable and dismisses all the employees as a result of that closure, that would be a redundancy situation pretty clearly. I do just want to say it is important to distinguish that total closure from the situation where an employer transfers its business to a new owner. In those circumstances, the transfer of undertakings regulations, the 2P regime, can operate to transfer the employment of the staff to the new owner automatically. And in those circumstances, the employees generally won't be redundant, except in certain insolvency situations. In 2P cases, where you've got a business transfer, different considerations apply, including consultation and informing employees about that transfer. So it'd be prudent to take advice. I'm not really going to focus on that today, but do just be aware that certain closures of business will trigger 2P. The next category of redundancy, then, closure of a particular workplace. So this is where an employer closes down a particular site where the employee is employed to work. When looking at where an employee works, you look at the place the employee is in fact employed before the dismissal, and not at the place or places where the employer could lawfully require the employee to work under the contract of employment. Where you have a mobility clause, I just want to mention that too. That's a clause in a contract that says, okay, instead of working in a particular location, the employer can also require you to work in a different location. Just to give an example of that, you may have an employee with a contract that says your normal place of work is our office in Oxford, but we can require you to move to our site in Reading. Now, if that employer needs to close down its Oxford site, that employer would have a choice whether to make the employee redundant because Oxford is closing, or invoke the mobility clause and contractually require the employee to move to Reading. The final situation that is a redundancy definition is where you have a ceased or diminished need or requirement for employees to carry out work of a particular kind. That can include situations where you've got fewer employees needed for the same amount of work, less work available, or the employer just no longer needs employees to do the work. So they're the different categories of redundancy. Employees with over 2 years of service have the right not to be unfairly dismissed by their employer. That's a right that, as I say, accrues when you have 2 years of service. But from day one, employees do have rights not to be selected for redundancy due to certain automatically unfair reasons. So there's no need for a qualifying period in order to bring a claim in connection with whistleblowing, health and safety, discriminatory reasons, including pregnancy, to name a few. So even from day one, if you're selecting people for redundancy, you need to be careful and clear about why you're doing so. In order to defend an unfair dismissal claim, for that dismissal to be fair, an employer needs to have, firstly, a potentially fair reason. Redundancy, in the meaning of the statutory definition we've just discussed, is a potentially fair reason. But on top of that, the employer must act reasonably in treating that reason as sufficient to justify dismissal. And that's generally going to mean, in a redundancy context, that there is a fair selection process, that there's consultation with the staff, and also consideration of alternative roles. If a redundancy is unfair, what does that mean? Well, an employer risks exposure to unfair dismissal claims, and that's problematic for a number of reasons. Firstly, reputationally, it's not likely to be a good thing to have unfair dismissal findings against you in the tribunal. And there is a public register of tribunal judgments that potential candidates, for example, if you're recruiting, can search and see if there are adverse findings in the tribunal against you. But also there is exposure, obviously, to compensation. And in addition to redundancy pay and notice payments, an employee could be entitled to compensation for their financial losses flowing from the unfair loss of their job. And that's capped at the lesser of a year's pay, or £88,519, although that cap comes off if it's found that the true reason for dismissal is discriminatory. So there's financial exposure and reputational exposure. Good reasons to get things right. So let's have a look now at the redundancy process and what you need to do in order to make a redundancy fair. First thing is, how do you fairly choose who is to be made redundant? Fair selection is crucial to avoiding unfair dismissal claims. Fair selection generally involves the fair application of selection criteria to a pool of employees. So in any case, you start by identifying the pool from which you will select those to be made redundant. Now, clearly, if the company is closing down its business altogether, the issue for the pool for selection won't generally arise because it's all the employees in that place that are going to be potentially redundant. Equally, if you're just removing one role from your structure that's a clear standalone position, then you might pretty easily determine that you just have a pool of one person who is at risk of redundancy. However, in many cases, employers will be contemplating reducing headcount across a particular business area, or reducing the numbers in a group of staff all doing very similar roles, in which case the pool from which you are selecting will need to be considered. There aren't any fixed rules on how an employer should define a selection pool unless the employer has collective agreements on that subject or has agreed a particular process with a trade union. So generally, there's a pretty wide degree of discretion for the employer on thinking about your pool. But the type of work carried out by employees should clearly be considered. And if there are other employees that do jobs that are interchangeable or comprise the same or very similar work, even at a different site, then the employer should consider widening the selection pool to encompass those employees. I do just want to say employees can become disgruntled, and it's quite a common line of attack for an employee to challenge the selection pool, particularly if they've been treated as being in a very narrow pool or even in a pool of one. You can imagine the argument, you've told me my work is drying up, but why haven't you considered so-and-so? They sit down the corridor and they effectively do the same job as me, so why me? So it's important for an employer to really carefully consider its pool and have good reasons to justify why it took a particular approach to pooling. Once you've thought about your selection pool, we then need to turn to consideration of selection criteria. How are you going to pick who within that pool is going to be provisionally selected for redundancy? And you should ensure that insofar as possible, these are objective criteria and are fairly applied. Tribunals have made it clear that employers should seek to establish selection criteria that don't depend solely on the subjective opinions of the people selecting employees for redundancy, but that can be checked objectively against objective measures like appraisal records, disciplinary records, measurable performance such as sales records or billings, etc. Just to cover a few common selection criteria and the pros and cons of those, skills, competence and experience. Now, clearly, an employer is going to find it useful to select on the basis of skills, competence and experience in order to retain the best people within the organisation. In doing so, try to tie it to objective things, as I said before, like appraisal records, and be careful with vague terms like scoring for attitude. There is case law where that's been described as a dangerously ambiguous and vague criterion. Attendance is a common one, and while employers can use attendance records as criterion for selection, you need to consider the period over which attendance is reviewed and the reasons for the absence. To avoid risk of discrimination claims, you should exclude any absences that are linked to pregnancy. And you also need to think about, some absences may be very heavily tied up with disability related issues, and so you ought to consider excluding absence caused by disability in appropriate cases. Disciplinary records is another common one. Disciplinary records can be taken into account in the selection process. It's good practice only to take account of unexpired warnings. And then the last one I wanted to just mention is last in, first out. That was a very much a traditionally used criterion to select the most recent employees as the ones who are to be selected for redundancy. But do be careful with that. It can be seen to discriminate against younger workers who've accrued less service and so could be arguably tainted by discrimination. Again, the selection criteria used are a common line of attack for employees who believe they've been unfairly targeted for redundancy. So spending time really thinking about some helpful objective criteria is a good use of time when you're planning a redundancy exercise. It's also good practice to think about your methods of scoring. More than one person can be, it's good practice for more than one person to be involved in the selection process to reduce the risk of perceived bias or discrimination. Often that's by having two people, both of whom know the individuals concerned, carrying out the assessment and separately, and then perhaps coming together to discuss the outcomes or for the scores to be averaged and applied. And it's generally good practice to use a scoring matrix, so a score sheet that attaches certain weights and scores to each criterion. And that matrix gives each employee a final score on which the redundancy selection is based. And then once all the scores have been worked out, the employees with the lowest scores will be the ones provisionally selected for redundancy. I now want to move on to the issue of individual consultation. Individual consultation with employees is absolutely essential, even if you are also collectively consulting with unions or employee reps. Consultation with individuals must be meaningful and must take place at a stage where decisions have not yet been taken. If you were to issue notice to staff and then consult, clearly that would be a clear signal that the consultation process is effectively a sham and the dismissal will be unfair. The consultation process is to allow the employer to explain the basis upon which the employee has been provisionally selected for redundancy, give the employee the opportunity to express his or her views, to raise any questions, and to discuss or identify any alternatives to redundancy. The requirement to consult doesn't mean that the parties ultimately have to agree with what each other are saying, and often there just won't be an agreement, but there does need to be a dialogue, and for the employer to listen and consider rather than just dismissing any points that the employee makes out of hand. Genuine engagement with the employee is required. As it says on my next slide there are no set rules regarding the number of individual consultation meetings held or the exact process to go through. And what's appropriate will largely depend on the circumstances, the numbers of employees involved, the particular roles. But a typical individual consultation process would involve the following steps. Firstly, I would normally expect there to be an initial meeting with employees, usually in a group setting, to announce the likelihood that redundancies will be necessary. At that meeting, the employee should set out the background to the situation, inform the employees about any options that the organisation has already considered to try to avoid the potential redundancies, outline the broad proposals for taking the matter forward, including the proposed criteria and how those are going to be applied. The employee should have a chance to put forward any suggestions that they might have and the opportunity to ask any questions. Following that, I would then expect there to be a process of individual meetings with the employees who are provisionally selected for redundancy, outlining the basis on which their provisional selection has been made. I usually expect at least 2 individual consultation meetings with each employee to consider the basis for their selection, the pool, the selection criteria, their particular scores, possibilities for redeployment, assistance that might be offered to them. So that could be in the form of, if you have an employee assistance programme, directing them to that if they're finding the process particularly stressful or difficult, but also covering any assistance that might be available to employees if their redundancy is confirmed, perhaps in the form of support with CVs or outplacement counselling. And I'd normally also expect redundancy entitlements to be covered if selection is confirmed, so the payments that the individuals might expect to receive. And employees should be permitted to be accompanied to those meetings by trade union reps or a colleague. I would advise employers to carefully document your process, have written invitations to meetings, keep minutes of those meetings, and follow up on any suggestions made by the employee in writing, just so that you have a good record of the process that you have followed, so that if you are ever challenged, you have good evidence. Ultimately, if a decision to dismiss is confirmed and the redundancy is confirmed, then it is also good practice to allow a right of appeal. And generally speaking, someone other than the original decision maker should conduct that appeals process. Consider your location and timing of meetings. Give adequate notice of meetings to allow people to prepare and digest the information from the previous meeting. And don't rush. I think that's a really important one in a redundancy context. Employees often have the sense that the employer is perhaps just jumping through hoops. You're just consulting with me because you have to from a legal perspective. You don't care about what I'm going to say. So you really want to make sure that your meetings are conducted in a way that people feel that this is a meaningful process and that they really do have a genuine opportunity to be heard. Meetings can be remote. I've flagged on the slides there the impact of COVID-19. Clearly, it's been difficult to have face-to-face consultation meetings in recent months, but yeah, it is acceptable for meetings to be conducted remotely. And I should also add as well that it is clear that if you have staff on furlough who are not allowed to work because they are furloughed, they are permitted to participate in a redundancy consultation process. Ultimately, the golden rule with individual consultation is don't give the impression that decisions have already been made, right up to the point that you confirm dismissal. You want to very much talk in the language of these are proposals, this is what we're planning, not this is what is happening. Just so you really emphasise the fact that this redundancy consultation process is being conducted with an open mind. I think as well, it's really helpful for managers who are conducting these meetings to fully prepare for them so that you can preempt and think about any questions that you may be asked by employees. And I've put on the slide there a number of questions that are common and that you should really think about before you start conducting these meetings. People are likely to ask, why me? Why not someone else? Be prepared to talk about your pool and your selection criteria and your scoring process. How will the business manage without me? What will the new structure look like? You're probably going to get questions about, well, what's happening? I do all this really, useful and important stuff. What's happening to that? Be prepared to talk about what the structure is going to look like and how that is going to be achieved going forwards. How long will the consultation take? Have a plan. What's the package, the notice period? How much leave will I have if I'm made redundant? Be prepared to talk about the financials. What help or support is available to me? Can't I be reallocated to a different job in another team? What if I'm due to retire? What impact is this going to have on my pension? These are all questions that you should think about and prepare. I think as well, really show understanding. It's very normal for a range of emotions to be shown during redundancy consultation. Employees are often angry, shocked, sad and upset. And I think the important thing for managers handling these sorts of consultation meetings is to show empathy, be sincere, but at the same time remain calm and neutral to present the business side of things. I now just want to talk about alternative employment. Employers must take reasonable steps to find alternative roles for employees who might otherwise be dismissed by way of redundancy. And a failure to consider alternatives could make a dismissal unfair. What is reasonable is ultimately a question that the tribunal would decide, but will include identifying possible vacancies within a company and inviting an employee to consider those vacancies or express interest in them. Don't make assumptions that just because an alternative position is more junior, involves a pay cut or a loss of status, that an employee won't be interested in it. An employee might be interested if such a position is the only alternative to redundancy. And so the safest course of action is to provide employees with details of all vacant positions. And it's worth mentioning as well that you do need to consider vacancies across a corporate group. So that does involve looking at other companies, if there is a family of companies, to see if there are potential vacancies elsewhere. Do note that accepting or unreasonably refusing an offer of suitable alternative work can lead to an employee foregoing their entitlement to a redundancy payment. And I also just want to talk about trial periods. If the terms and conditions of the new job being offered are different from those of the old job, and they commonly will be, the employer is entitled to a 4-week statutory trial period, or longer if agreed beforehand for the purposes of retraining. The purpose of that trial period is really to give the employee the chance to decide whether or not that new job is suitable for them. And if during or at the end of that period, either party, the employer or the employee, reasonably considers that the redeployment isn't working or that there are no other opportunities, then the redundancy payment would still be payable to the employee. Employees who have at least 2 years continuous service and have been given notice of dismissal by reason of redundancy are entitled to reasonable paid time off during their working hours to look for new employment or make arrangements for training or future employment. And that could be an employee who's been given notice of redundancy but needs time off during their notice period to attend an interview or to visit a job centre or to have a meeting with a recruitment agent. So as the employer, you should be permitting reasonable time off for those purposes. I do just also want to talk about employees on maternity leave. An employer must ensure that it includes employees on maternity leave in the redundancy consultation process. You also need to consider that any selection criteria are objective and non-discriminatory and are fairly applied. And I mentioned earlier about with your selection criteria, if one of them is absence, you would need to exclude any pregnancy-related absence to avoid discriminating on that basis. It's also really important to bear in mind that employers need to take into account that employees who are made redundant while on maternity leave have special rights relating to being offered suitable alternative work. Effectively, women on maternity leave have priority in relation to any available vacancies. So if you have a redundancy situation and you have alternative roles available, the person on maternity leave who is at risk of redundancy effectively gets first dibs over that alternative vacancy. And that's very important to remember, otherwise you could find yourself on the wrong side of a discrimination claim. The other point relating to maternity is that once an employee has qualified for statutory maternity pay, they remain eligible to be paid that for the full period, even if they're made redundant before or during the maternity leave period. So you could have somebody who's triggered maternity pay, make them redundant, but still be having to make them maternity payments for the duration of their maternity leave. So do bear that in mind. Another key point that I think is really, really worth mentioning here is that if you are embarking upon a redundancy exercise and you're starting to make plans for a redundancy exercise, do remember that any documentation, including emails between managers, are likely to be disclosable in any tribunal proceedings. So correspondence or other documentation that evidences that decisions on redundancy had already been made before consultation would be very damaging in a tribunal. I have seen cases where employers have effectively had a hit list of people who are going to be made redundant before there's been proper pooling or selection criteria. And yet clearly that type of documentation can be very damaging in a claim and could be disclosable in relation to a data subject access request or in tribunal proceedings. So take care with your documentation and think what's being created. Finally, I just want to talk about the entitlements of people who are made redundant. Employees are entitled to be given notice to terminate their employment. An employee's contract of employment will normally specify what their notice periods are, but if they don't, then a reasonable notice period is implied. In either case, whether it's specified in the contract or we're implying a reasonable notice period, the period of notice must never be shorter than the statutory minimum notice periods that are linked in with length of service. Employees will often work notice, but many employers will consider making a payment in lieu of notice instead, rather than requiring employees to work out their notice. Do bear in mind that if you do that without it being something your contract provides for, then strictly an employer would be in breach of contract, which could render any restrictive covenants in your employment contracts restraining the activities of employees post-termination invalid. And therefore, if you really want to be able to police post-termination restrictions, you just need to be careful if you are paying in lieu and check that you've got the contractual entitlement to do so. Redundancy pay. Any employees with at least 2 years of continuous service are entitled to redundancy payments. The amount is calculated based on a statutory formula that takes into account age, length of service, and salary. Maximum of 20 years employment is taken into account for those purposes. And there's a cap on a week's pay, statutory cap currently set at £538 per week. There's a very useful online government calculator for calculating redundancy payments, and I've put the link to that on my slides. Just to mention on enhanced redundancy payments, statutory redundancy payments are often fairly small, and some employers offer enhanced redundancy payments, perhaps under a sort of formal enhanced scheme, or sometimes as a discretionary arrangement. If you have an enhanced redundancy scheme, you do need to make sure that it's not discriminatory under the age discrimination legislation. And there is specific provision in the legislation for an employer to enhance statutory redundancy payments in particular ways. I just want a quick word about settlement agreements. If an employer is enhancing redundancy payments, do consider whether you want to make it a condition of receipt of that enhanced payment that the employee signs up to a settlement agreement. That's a formal contract where in return for an enhanced sum, the employee enters into a binding contract that it won't sue the employer in relation to their dismissal or any other claims stemming from the employment. So it can be a really good way for an employer to buy certainty that claims won't come back to bite them. It is a requirement that individuals will need to take advice on the terms of such a deal and have their advisor sign off an agreement. So there is some added expense of having the agreement drawn up and usually contributing to the employee's legal fees in taking that required advice. But in some circumstances, particularly if there is something in the situation that means that it's a bit of a risky one, then that can be money really well spent. And we frequently advise both employers and employees on settlement agreements. So if that's something you need, do get in touch. And then finally, I just wanted a word on taxation. Statutory redundancy payments are exempt from income tax, but they are taken into account in determining whether or not the total compensation paid to an employee exceeds the £30,000 tax-free limit. Non-statutory enhanced redundancy payments are also taxable only to the extent that they exceed the £30,000 limit. So there is a way of giving employees some money tax-free on the termination of their employment within that £30,000 band. Notice pay, payments in lieu, holiday pay and other contractual payments will all be taxable. That draws everything I wanted to say today to a close. So thank you very much for listening, and do get in touch with me, Nicola at juliantaylorhr.com, if there's ever anything that I can assist with. That's all on this particular episode of Tips for Employers, but do tune in next time when we'll be addressing a different topic that you might find useful. Thanks a lot, everybody, and enjoy the rest of your day.